So a bunch of gun tubers and other characters have been pretty aggressively hyping a claim that the ATF's brace registration is a trap of some sort. And that we're all felons if we don't buy a gun trust, or something about having to chop up all of our imported pistols because of 922R, or that you're going to be a felon in 88 days for some reason. Let's talk about what's actually going on and just what sort of dumb juice these people are drinking and feeding to their audiences. So there's two categories of misinformation going around here that I see. One is with regard to imported pistols in 922R, and the other is with regard to NICS checks and an 88-day time limit. Let's start with the 922R one, because why not? Also, I have a video all on 922R. You should check it out if you haven't seen it. In this one, we have various tubers and other people talking about how somehow the brace rule is going to mean that you have to chop up or hand in any imported pistol. They say this while posting a screenshot of the final rule, generally highlighting half of a sentence on page 247. No attention should be paid to the rest of the page or the context of that, apparently. What they highlight is talking about imported pistols with braces. ATF assumes this group may use another scenario, such as destroying the firearm or turning it into the ATF, and cutting it off there. From my little bit of snooping, aided by the investigative Rat Bureau and Mongoose of the Fudbusters Discord, it seems the origin of this piece of FUD lore is the Instagram of Frack Action, which is the group of lawyers assembled by Franklin Armory to do funny things with the ATF, which I support. And I don't want to urinate on Frack too aggressively. After all, they are well-intentioned, but this is intensely dumb. The Frack Instagram post reads, "Written in the stabilizing brace final rule, ATF has concluded that any foreign-made pistols with stabilizing braces would be assembled in violation of 922R, as the firearms are retroactively being considered rifles. As such, registration or removal of the brace would not bring the firearm into compliance. According to ATF, this leaves destruction or surrender to ATF as the only available options for foreign-made firearms with braces. This would include imported pistols where the brace was added at any stage, regardless if done by the user or the importer. Hashtag Washington, D.C., hashtag Washington, hashtag ATF." So Frack's interpretation, based on this sentence, is that since ATF is saying brace pistols are rifles, and since assembling a rifle with more than 10 specific imported parts is a 922R violation, that the only options for anyone who has had a brace on their imported pistol, since pistols aren't subject to 922R and thus usually have only imported parts, must be destroyed. I'm happy to report that this isn't how this works at all. Since I know some of you will be like, well, but look, it says... Let's actually read the damn document these people purport to be quoting. And I also just say, like, I hate when it comes out and I have to be talking about how the ATF isn't actually being that evil. The ATF's being intensely evil. But come on, guys. There's enough crap the ATF's doing for real to not make stuff up. For one, where is this in the document? Well, if we scroll up to the discussion on page 238, which this is a response to, it is about cost estimates for the regulatory impact analysis. 922R is referenced a total of 6 times in the entire final rule, all of them in the departmental response to comments regarding cost estimates from page 241 to 247. 922R was brought up by a commenter saying that ATF failed to take into account the cost of US-made parts to bring a firearm into what they said would be 922R compliance. ATF's discussion correctly posits that this is an incorrect reading of 922R. 922R applies only to the assembly of a firearm. As you can see, there is no consequence for possessing a firearm that was made from imported parts in violation of 922R. Indeed, if this were not the case, things like Noriko Mac 90s would be contraband. And yet, here they are. The comment ATF was responding to was suggesting that the cost of purchasing US parts must be considered because the commenter asserted that people who owned these firearms would have to replace the parts in order to come into compliance. That is simply not the case, as the mere possession of a firearm made from imported parts is not a crime, nor is registering it. Remember, the whole crux of this rule is that it applies to firearms that people have that already have braces on them. There is no assembly to be considered a 922R violation, and thus there is no need to buy US parts. Then, in the section people keep highlighting, if you actually read it, it says, for the purposes of costs outlined in the standalone regulatory impact analysis, this group may use another scenario, such as destroying the firearm or turning it into the ATF, by using the population derived from the bump stock type devices as a proxy. The opinion there is how this group who asserted this question can address regulatory impact cost. That is all the ATF is saying here. That if any 922R violation occurred, it already occurred, and thus there is no need to take part purchases into account, and destroying the item would not cure it either because it already happened. Again, I must stress, there is no consequence for simple possession of a firearm that was made from imported parts. If you want to argue otherwise, show me the statute where you can be charged for possessing a firearm that was assembled in violation of 922R. I'll give you a hint. You can't. Others have misinterpreted the Form 1 being an application to make and register, suggesting that this means the filing of the form itself must be a 922R violation. This is insane, as the very rule recognizes that the firearms were already assembled. It may have impacts, it certainly would have impacts for importers who already have pistols in their inventory that have not yet put a brace on. Obviously, going by the new rule, that would not be a good idea. But ATF is not here saying that, that it is going to perceive these existing guns as 922R violations. That is not possible. And look at the history of 922R enforcement actions, and you'll see there. I don't think that's what ATF is suggesting here at all. Still, I know some of you will be like, oh, but they're going to say you assembled it and they're going to come get you. Well, hold on to that thought, because it's the same reason the other major nonsense being spread here is nonsense. This is the whole, after 88 days, the ATF is going to consider you a felon, in all caps, which, yeah. I can't tell if this one is just a regrettable case of people running with a lead straight into the wall, or a group being intentionally disingenuous for the purpose of clicks and fundraising, which we've never seen in any three-letter gun rights agency at all. The origin of this is an interview on Guns and Gadgets between Jared of Guns and Gadgets and GOA attorney Stephen Stromboli. Jared talks about a trap inside the ATF rule. The first issue here is the concept that you're incriminating yourself if you Form 1 A-braced pistol. Then Stephen talks about the background check process and states that after 88 days, a background check is denied. Jared goes on to suggest that there's no way these forms will be processed in 88 days, and thus the forms will be denied, and everyone who has submitted one of these forms will be an insta-felon. Now, I talked to Stephen about this, and he did ask Jared to correct the video. He added a little asterisk in there, but many people are audio only. So immediately after that, Stephen suggests that ATF will use the delayed background checks to disapprove individuals and then use the submitted Form 1s to do something to them. Stephen then says that he went to some unknown person at the ATF booth at SHOT Show who told him that if someone's form is denied, ATF would take an enforcement action at that time. Okay, there's a little bit to unpack here. First of all, what's being discussed here is confusing because there's a lot of terms being used interchangeably when they should not be. For one, and Stephen actually asked Jared to correct this, the 88 days is not from the date of form submission, it's after the background check is submitted. And it's not an 88-day clock from submission to approval, it's the background check itself. It's if the background check is inconclusive for more than 88 days, which is a very rare situation. This is actually policy as a result of the need to purge identifying information from the NICS database. It does not mean you are denied or found to be prohibited after 88 days. It means that the check has been purged and is thus no longer in the system. And ATF policy is to deny the NFA application or disapprove the NFA application if the background check remains open for 88 days. The suggestion here, and the theory advanced, is that an individual who submitted a form, right, they gave all this information to the government, and is then denied administratively after this amount of time, would be a felon in possession of an SBR, and that ATF's going to come straight to your house and get you. And I actually had a great phone call with Stephen about this, and we agree on what the law actually says and who's impacted. What we disagree on is what the results and implications are. I did have a conversation with a different individual who was decidedly less polite, but whatever. In Stephen's defense, a lot of what he said is true, but people have aggressively misinterpreted it and blown it entirely out of proportion, including some people that really shouldn't have. The public idea now, it seems, as a result of all of this, is that if your form isn't approved in 88 days, you've instantly become a felon who's given all of the evidence needed to convict them to the ATF. And this has caused a flood of phone calls to come in, not only to myself, but other attorneys who work in the space. In fact, a friend in Texas has had he said he's had hundreds of calls on people just freaking out over this. Well, I'm glad to tell you guys, it just plain doesn't work like that. For one, let's talk about who gets stuck in an open NICS check. It isn't because of overloading systems like we saw during Corona, which did not take that long. It's because there is some record open in some jurisdiction that may be prohibiting on the individual. I've helped plenty of clients with this problem. Often it's cases that were never properly closed within the court database or incorrect database entries otherwise. This is not very common though. This is only about 1% of NICS checks, of all NICS checks, not just firearms, right, that result in an indefinite open. And they are often cured with a phone call or two to the source of the record. What's really erroneous here is the idea that ATF is going to be able to slam your door down because you filed a Form 1. On that, we've got to talk about Haynes v. United States. Haynes was before NICS checks were a thing at all. Haynes argued in 1967 that the requirement to register a machine gun was unconstitutional as applied to him because he, as a convicted felon, could not register it without incriminating himself. The Supreme Court agreed and held that individuals must be fully protected against self-incrimination in order to be able to comply with the registration requirements of the NFA. That's why 26 U.S.C. 5848 provides that no information obtained from an NFA submission can be used in any way as evidence against a person directly or indirectly with respect to a violation of law occurring previously or concurrently with the application, except for lying on the form itself. So no, they can't come after you for submitting a form during the grace period because there is literally a federal law that's been on the books exactly because the government wanted to try that crap in the 60s and lost. Of course, you can reasonably be wary of the government's use of discretion in all forms. But for this and the 922R concern, I don't think it's reasonable to suggest that filling out a Form 1 makes you an insta-felon. Plus, there are a whole host of other protections here. This is just not a very reasonable assertion. Of course, those people, I will grant, if you file your Form 1 and it's denied after the grace period, it does put you in an awkward situation where you have to look at your options, possibly dismantling the item. But it doesn't make you an insta-felon. Plus, given the current climate, actions that unlawful on the part of the government aren't very likely, as they would severely undermine the constitutionality of the NFA, which we're attacking anyway. So to put a bow on it, as for the 922R concern, there is no way to be charged for simply possessing or registering a firearm that was assembled in violation of 922R. The discussion was limited to regulatory impact analysis. 922R was mentioned nowhere else in the final rule, and 5848 would prevent prosecutions based on information provided in the forms alone. As for the 88-day concern, it is not from the date of submission. It is from the date of the background check start. Only affects 1% of people who have a potential problem with their record. It can be cured during that period, and 5848 prevents criminal prosecutions based on information provided in the forms. So that's it. I hope you all know how much I hate making videos like this, but there is a huge problem with outrage farming and misinformation in our community. No one wants to fight the government more than me. I actually passionately enjoy it. But the government is actually behaving in enough maniacal ways that we need to fight. We need to focus on the stuff that they're actually doing and not run around in blind panic over nonsense. In addition, I grow increasingly concerned about the way we as a community are caring less and less about the truth. We're fighting a decades-long battle of law and public opinion that we're on the crux of making major advancements on, and the people on either side of the extremes are no longer up for grabs, but the fence-sitters are. We can get those people on our side by being level-headed and unrelentingly rational. Running around screaming, putting pictures of court buildings on fire in every video thumbnail, it doesn't exactly evoke the idea of a reasonable actor. I'm not saying this just to complain, although I am enjoying complaining about it. I'm saying because I want us to win. Speaking of winning, if you're on the west coast of Florida, are affected by the brace rule, especially if you are a business, please hit me up on the Twitter Bird app. That's it for today, guys. As always, I super appreciate y'all watching and subscribing. If you want to support me more than that, I've started up a Patreon, a Subscribestar, and a Utreon where I've got some neat benefits for you guys. This kind of support will help me to make more content more regularly, which I really want to be able to do. There's also a link to merch, including the Magic ATF ball and affiliate links in the description below. For now, y'all take care.